Okay, let's dive in. You've brought us a stack of sources today, and it looks like they cover a really significant legal decision. Big implications here.
That's right. We're looking at a ruling from the Ninth Circuit Court of Appeals.
Right, and that circuit covers states like California, Washington, Oregon, Hawaii, places often associated with pretty strict gun laws.
Exactly. And the topic is a major finding on the Second Amendment right to carry a firearm in public, specifically openly carrying.
Okay, so our mission today is to unpack this ruling, really get into the court's reasoning based only on these sources you've provided.
Yeah, and figure out what it actually means for those states in the Ninth Circuit, and maybe, even beyond.
All right, let's get started. So, the source material says this all began in Hawaii, the Big Island specifically.
That's where the case originated. And yeah, Hawaii's general firearms law sounds quite restrictive based on these documents.
Oh, so what did it say?
Well, the basic rule was you had to keep your firearms at your place of business, your home, or where you were temporarily staying, not really out and about.
Okay, and getting a license to actually carry a gun, either concealed or openly, that was tough.
Extremely tough, according to the sources. For a concealed carry license, you had to demonstrate a specific reason to fear injury to their person or their property.
So not just a general desire for self-defense, you needed like a documented threat against you personally.
Precisely. It had to be specific. And for open carry, even harder.
Really? What did that require?
The state law required showing urgency or need and that you were engaged in the protection of life and property.
Okay.
But then the county regulations added another layer, saying open carry was only proper in the actual performance of his duties or within the area of his assignment.
Wow. So that sounds like it functionally limits open carry almost entirely to like security guards or people in similar jobs.
That's exactly the situation the sources describe. It wasn't really available to the average citizen.
And what about just transporting a gun, say, to the range? Was that restricted too?
Yes, heavily. If you didn't have one of those near impossible to get licenses, you could only transport an unloaded firearm for very specific reasons, like going to a repair shop, a shooting range, hunting, police station, that sort of thing.
And it had to be unloaded and in a container.
Unloaded and in an enclosed container, yes. So just moving your firearm around wasn't simple, let alone carrying it for self-defense.
Right. And this brings us to George Young. The sources say he applied twice back in 2011.
Correct. Applied twice for a license to carry a handgun, openly or concealed.
And was denied both times.
Both times. Because he couldn't meet those incredibly high standards set by the Hawaii law.
Which, naturally, led to his lawsuit. He argued the county was basically violating his Second Amendment rights by making it impossible for a normal person to get a carry license.
That was his claim. And the county's defense, the sources say, relied heavily on a previous Ninth Circuit case, Peruta.
Peruta, I remember that one. Didn't that case say there was no Second Amendment right to concealed carry?
It did. The Ninth Circuit en banc ruled there wasn't a right to concealed carry specifically. So the county argued, look, Peruta already decided this. Young's claim is baseless.
But the court, in Young's case, saw a difference. They didn't just dismiss it based on Peruta.
No, they drew a crucial distinction. The sources emphasize this point. The court explicitly stated that while Peruta dealt with concealed carry,
Right.
the court had never actually ruled on whether the Second Amendment protects the right to carry a firearm openly in public.
Okay.
Yeah.
So that specific question, open carry, was still on the table.
Exactly. It was an unanswered question in the Ninth Circuit, and Young's case forced them to address it head on.
So how did they approach answering that question? What was their method?
The sources lay out their framework pretty clearly. They used a two-step test.
Good.
Step one, does the challenged law, in this case, Hawaii's restrictive licensing scheme burden conduct that's protected by the Second Amendment?
And step two.
If the answer to step one is yes, then step two is to apply the right level of constitutional scrutiny to see if the law is still justifiable.
Got it. And the sources mentioned the court sort of signaled its view on the Second Amendment early on. Something about it not being a lesser right.
Yeah, that's interesting. They actually quoted Justice Thomas from a dissent he wrote in another case denial.
What was the quote?
He said the Second Amendment is not a second-class right or a constitutional orphan. By including that, the court seemed to be saying, we're taking this right seriously, giving it its full constitutional weight.
Okay, so setting the stage. Step one, then. Is carrying a gun openly in public for self-defense actually protected conduct? How did they analyze that?
They started, as you'd expect, with the text of the Second Amendment itself, and crucially, how the Supreme Court interpreted that text in the Heller and McDonald decisions.
Some big ones.
Yeah,
And the focus was on the phrase bear arms,
exactly. They zeroed in on bear. The court specifically cited Heller's definition.
which was,
Heller defined bear as to wear or carry upon the person or in the clothing or in the pocket,
okay, so carrying it on you.
for the purposes of being armed and ready for offensive or defensive action in a case of conflict with another person.
That seems pretty direct.
No.
Carrying a weapon on your person, ready for a potential confrontation.
Right. And Heller also clarified that bear implies caring for a particular purpose, which the court here understood to be confrontation, specifically for self-defense.
So just based on the text and what the Supreme Court already said in Heller and McDonald, their initial takeaway was,
Their initial conclusion from the text was strong. It points directly toward a right to carry firearms publicly for self-defense.
okay, text points that way.
Hmm.
But the sources really emphasized the court didn't stop there. They did a deep dive into history.
Oh, absolutely. This historical analysis was really central to their entire decision. They wanted to know how the founding generation understood bearing arms.
What kind of historical sources did they look at?
They went way back, looked at things like Sir William Blackstone's commentaries on the laws of England.
Blackstone. Why was that relevant?
Well, Blackstone discussed the 1689 English Declaration of Rights. He described it as protecting a natural right of resistance and self-preservation, including the right of having and using arms for self-preservation and defense.
Connecting arms bearing directly to self-defense, potentially outside the home.
Precisely. But they didn't just rely on English history. They looked heavily at American history, too.
Like what?
Like 19th century state court decisions. The sources mention cases from Kentucky, Tennessee, Alabama, Georgia, Louisiana, states grappling with gun rights questions relatively closer to the founding era.
And what did those old state cases generally say?
The court found a consistent theme. These decisions showed a widely held belief in a right to carry firearms in public, and significantly, many of them distinguished between open and concealed carry.
How so?
They often ruled that carrying openly was the protected right, while carrying concealed was something states could regulate or even prohibit. That distinction was apparently quite common back then.
That's fascinating. So the historical view was almost the opposite of some modern debates. Open carry was seen as the core right. Concealed carry was viewed with more suspicion.
That's the picture the court painted based on those sources, yes. They also looked at laws passed by Congress after the Civil War.
Why then?
Those laws aimed to protect the constitutional rights of newly freed slaves, including the right to bear arms from state infringement. The court saw this period as reinforcing the understanding that carrying arms publicly was considered a fundamental American right.
Okay, so pulling all that history together, Blackstone, the 19th century state cases, the post-Civil War stuff, what was the Ninth Circuit's big conclusion from this historical canvas?
The sources quote the court summarizing it powerfully. They said these different historical sources each reveals a single American voice.
A single American voice saying what?
Saying that the right to bear arms must include at the least the right to carry a firearm openly for self-defense.
Wow, that's a very strong finding based on history.
It is. And the court was careful, the sources point out, about how they used English law, like the old Statute of Northampton.
How did they frame that?
They said they only considered English law to the extent it shed light on the original public understanding of the Second Amendment in America. And they found the American understanding was, quote, unambiguously consistent with a robust Second Amendment right to open carry, suggesting it differed from some earlier English restrictions.
So the American tradition was distinct and clearly supported open carry in their view. Did they address arguments against this historical rating, like from the dissenting judge?
Yes, the sources mention they directly pushed back on the dissent's interpretation of certain historical laws, like surety laws.
Surety laws, what were those?
Basically, laws where if someone was reasonably accused of being dangerous, they could be required to post a bond, a surety to guarantee they'd keep the peace, which might include restrictions on carrying weapons for that specific person.
Okay.
The majority opinion argued the dissent misinterpreted these. They weren't general bans on public carry for everyone. They were targeted measures against individuals deemed a threat. They weren't evidence against a general right to carry openly.
Got it. So meticulous historical arguments here. Okay, step one complete. The court concludes open carry for self-defense is protected by the core of the Second Amendment based on text and all this history. What about step two? applying this to Hawaii's law.
Right. So, having established the right, the court found Hawaii's law definitely burdened Young's ability to exercise that right. That moved them to the next question. Did the law essentially destroy the right for the average person?
And their answer was yes. How do they reason that?
They looked at the practical effect of the law. By restricting open carry licenses only to those whose job involved protecting life or property.
Like the security guards we mentioned.
Exactly. The court said this limited the right to a small and insulated subset of the population.
And they connected this back to Heller.
They did. They drew a parallel. Just like Heller said the Second Amendment isn't only about serving in a militia, this court said the right to bear arms isn't only for security guards performing their duties.
Makes sense.
So their conclusion, based on the sources, was that the typical law-abiding citizen in Hawaii was entirely foreclosed from exercising this core Second Amendment right, the right to carry openly for self-defense.
Entirely foreclosed. So because it was practically impossible for the average person, it wasn't just a regulation, it was effectively a prohibition, a destruction of the core right.
That's exactly how the sources frame the court's finding. And because it struck at the core of the right, they rejected the dissent's suggestion to use a lower standard of review, like intermediate scrutiny. The law had to meet a higher bar, and it didn't.
And then there's that powerful concluding quote the sources highlight.
Yeah, it really sums it up. The court stated, but for better or for worse, the Second Amendment does protect a right to carry a firearm in public for self-defense.
Acknowledging the policy debates, but grounding it in the Constitution.
Right. And they added that while states can regulate the manner of carrying arms, that power isn't unlimited. Quoting the court again from the sources, the enshrinement of constitutional rights necessarily takes certain policy choices off the table.
Policy choices off the table.
Yeah.
Okay, so the Ninth Circuit panel issues this strong ruling. What happens now? What are the next steps legally?
Well, according to the sources, the losing party has a few options.
Such as?
They could petition for an en banc rehearing. That means asking the entire Ninth Circuit Court, or at least a larger panel of its judges, to review this three-judge panel's decision.
And that could potentially reverse the outcome.
It could, yes. It doesn't always happen, but it's possible. The sources mention a Fourth Circuit case about assault weapons bans, where an en banc court did overturn the initial panel decision. So it's a real possibility.
Okay, so en banc review is one path. What else?
They could decide to skip the en banc step or try it and lose, and then petition the U.S. Supreme Court to hear the case, asking for certiorari.
Right, asking the highest court to weigh in.
Exactly. If the Supreme Court agrees to take the case, then they would have the final say. But if the Supreme Court denies the petition, refuses to hear it, then this Ninth Circuit ruling stands as is.
And there's a third option, right?
Yes, the county could simply choose not to pursue any appeals, no en banc petition, no Supreme Court petition. In that case, the ruling also stands.
So if this decision does ultimately stand, either because appeals fail or aren't filed, what's the immediate practical impact across the Ninth Circuit? That's a huge area.
It's significant. The sources state the clear implication is that all states within the Ninth Circuit, California, Oregon, Washington, Nevada, Arizona, Montana, Idaho, Alaska, and Hawaii, will have to permit some form of open carry for self-defense by law-abiding citizens. Their laws can't completely foreclose that option anymore.
That would be a massive shift, especially for states like California and Hawaii with their current approaches.
A huge shift. And the sources capture that uncertainty, quoting one analysis saying, "Time will tell if states like California play ball or if they be beaten into submission by the courts."
Puts it bluntly. Okay, so wrapping this up, the core takeaway from our deep dive into these sources seems to be this. The Ninth Circuit, a court not always seen as leaning towards gun rights, engaged in a really detailed textual and historical analysis. And through that analysis, they definitively ruled that the Second Amendment protects an individual's right to carry a firearm openly in public for self-defense.
That's the holding.
And this ruling struck down Hawaii's very restrictive licensing system because it effectively made that right impossible for the average citizen to exercise.
Yeah, I think what's really striking here is that emphasis on the historical context, on the court searching for that single American voice from the past to define the scope of a right today. It really highlights a specific way of interpreting the Constitution, focusing on original public meaning.
Right. And it also underlines their point about fundamental rights setting limits. The court basically said, look, The Constitution protects this, so certain state policies, whatever their intention, just aren't permissible.
Which leads to a really interesting final thought for you listening to this. Given how heavily this ruling relied on interpreting history to challenge modern gun regulations, what does this tell you about that ongoing tension? The tension between how rights were understood historically versus contemporary concerns about public safety and policy.
Hmm.
What other questions does it make you think about regarding how we define and apply these fundamental rights today, especially when they clash with current societal issues or policy goals?
That's definitely something to chew on. How much should that historical understanding dictate things today? It's a core constitutional debate.
Indeed. Well, thank you for providing these sources. It allowed for a fascinating deep dive into a really impactful decision.
My pleasure. Always interesting to see how the courts grapple with these issues.